Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin and Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
So now the exit clause. The two ones I want to talk about have to do with the limits on exit and an evaluation. So I touched a little bit on the valuation, so let's jump up to the exit. So setting the time limits is the number one thing to do. Is really the early exit should be tied to some kind of forfeiture. That's you have to give someone an incentive to stay in, or if they want to leave, they have to give it up. And then the other part of it is on the exit from the company. So if they exit, what is that going to look like? Can I just walk away and take my shares? Do I walk away and do I get a cash buyout? So the evaluations factor into that. You can do formal evaluations. A lot of generic agreements would say, you'll go with book value, you'll go with an appraised value, but there's a cost to that, and there's sort of a volatility with that because a more specialized business, especially family owned, is going to have lesser of a value. That's just the way it is. So you can tie it to the sales. You can say, okay, if I leave, then I'm entitled to 1 year of gross sales, that type of a thing. Or I'm entitled to my salary for a period of time. Or if I leave, I'll stay on for transition free for 3 months. And all of those little details, they don't seem like a lot, but when they're not decided, they're catastrophic because no one knows what to do with them. So those are the type of things that you want to think about. What about future sales? What if you have things that have long lead times? What happens if you're not going to get paid off for like a year or two? I think about things like marketing companies where sometimes their jobs are just, it's all up front and they don't see the dividends until later on. I mean, you can even think about things like royalties with music and those types of things. So anything that has a long lead time, taking into account, what are we going to do about that? What about things like chargebacks? What happens if the business is such that when it goes out there, we know there might be service work, there might be warranty work, there might be returns. How are we going to, I don't want to cash somebody out and all of a sudden I'm stuck with that. We got to spell out all those types of things. And then finally, offsetting of losses like litigation. So what happens if we get sued on a product and how are we going to deal with that? Usually it's insured, but again, just trying to take into account those things. Okay, so we're going to talk about litigation. So they look at the parties' agreement. That's why I spent all that time talking about those different things, okay? The contract rules always, and they'll just go for there. So if I sue somebody for violations, it will be a breach of the agreement. It'll be a breach of contract, and I'll go, they were supposed to do this, and this, and they did not. I'm entitled to these damages because this. Next, they will go to the Business Corporation Act, the Illinois Limited Liability Act, or the Illinois Uniform Partnership Act. I gave you the citations there. Depending on how it's structured, there are provisions that are spelled out in those, which we're going to talk about the corporation side of them because they're the most detailed, that talk about what happens, okay? You don't want to rely upon the Business Corporation Act without a contract because the provisions are general and they tell you how to do them and they don't at the same time. What they do is they give parameters for a court to make a decision, but when I show you some of the remedies, you're going to be like, oh, that sounds really expensive, and it is. So it's good and it's bad. And then bottom, and see how I said, courts consider claims like fraud, but very often they're ignored by the courts because the primary obligations fall under the first two. So people are like, oh, he took all my money and all these other things. To prove fraud is really difficult. I mean, it's literally like embezzlement, theft of trade secrets, competition, those types, and of course you can bring those type of claims. But again, they always flow from a contractual obligation, A, or B, a statutory obligation, right? So if my contract says I can't do these things, easier for me to say, contract said A and you did B, than for me to come in and say, well, I didn't have a contract that said A, but I should have said A, so I'm going to sue you for fraud. You see how much different that is? Same with the Business Corporation Act. Business Corporation Act says you were supposed to do this. I never spelled it out anywhere, but now I don't think you did it, but it's my say-so, and so therefore I want a court to kind of decide it for me, and that becomes a bad thing. Okay? All right. Take this picture. Snap this picture. Snap this picture. Well, you actually have it in there too, but if you want a bigger picture, if you want the pretty color. All right. So the way that I have this, the underscore, so it's 805 ILCS 180/, each of those are the sections. So that's the citation under the Business Corporation Act. These are the key provisions I want you to know. Those citations, if you want to know what your rights are under a corporation, an LLC, or partnership, those three statutes I gave you, that's where you want to go, okay? I'm only going to focus on this first one. I'll give you citations in a moment. Because most people are corporations, and even if you're not a corporation, everything else kind of flows with the same logic. In other words, it might call it a member, but you'll see that the member and the shareholders are treated, kind of the same. Okay, so just some definitions. Okay, so the corporate level, the management level of a corporation, you'd have your president, your secretary. Those are the two you have to have, and your treasurer, maybe a vice president. Okay. No, they just have to have a president and a secretary, and they can just have one. So you just have to have one person who fulfills the role of a president and a secretary. President, because someone's got to run it. Secretary, someone's got to account to the state. It's pretty straightforward. Everybody else is known as a shareholder. Okay, shareholders are your owners. Okay, so you could have 10 shareholders and 2 officers of a company. So, for example, LLCs. Members are the equivalent of the shareholders. Members are your owners. Managers are who run it. If you have a member-managed LLC, the members manage at the same time. They're synonymous. If you have a manager-managed LLC, the members are just owners, and the managers are that equivalent of like the president and secretary. It's like your board of directors. It's the same concept. Okay. With partners, you don't have either of those. Partners are just 2 people or 3 people or 4 people that got together. Any 2 people that get together by default are partners. And the partners have whatever responsibilities they give each other. They're liable equally as partners, and they both have all the responsibilities and they have none of the responsibilities. So it's possible that one person could be doing it all, the other isn't, and there's no like fix for you. It's not like you can say, oh, well, they were supposed to, because it's not defined. That's why you need partnership agreements, most importantly. Most people don't have partnerships because people set up corporations usually for their own liability shields, but occasionally you might have partnerships if, like I said, a couple people want to go together and just kind of do some side jobs, and that you might have kind of a loose partnership. So I don't spend a lot of time on it, but I give you the provision just so you have it. Okay, so let's look at the Business Corporation Act. So I go from good to bad, and that's how the statutes spell out. So section 1205 is voluntary dissolution by all partners, so I bolded that. So if everybody agrees, you can do anything you want. There's nothing you cannot do. Okay, even inside of a corporation, by unanimous consent, you agree, you spell it out, you sign off on a consent, you're done. Okay, so don't worry about if you have agreement. We're not here about agreements. Anybody can figure that out. 1215 is voluntary dissolution by some shareholders. There's your more common thing. The issue is going to be, can we force a vote? Okay. If you go down to A2, it says 1/5 of the shares can call the vote. Okay, so 20% can call a vote if something's going. That's not too bad, right? So a minority shareholder can usually call the vote, but 2/3 have to vote in favor. So the minority person is going to bring it to the attention, but the majority is going to win that discussion. All things being equal, meaning if there's no kind of fraud or violations of anything, the minority shareholder can never beat the majority shareholder. And the percentage is going to be that by default unless it's agreed a greater amount or a lesser amount. So greater amount could actually, I have some agreements that go like 90, 95% intentionally, because it's literally saying I'm in charge and I never want you to be outvoted. Occasionally a unanimous vote, not often, but sometimes, because you can get deadlocked, but sometimes they're like, no, we all agree or none of us agree. But it can go down to greater than 50%, so it's majority. The reason I said greater than 50%, it could literally be 50.1%. I mean, it's not an even number. So just know that those are the numbers that you care about, okay? So if you are in a number that's bad, right now you need to go back, you need to figure out those agreements, because you got to put yourself in a position where you're not, okay? So in a situation where you're talking about 7 people, You got to get 4 of you to the table. Well, you can, 2 of you can bring the vote, but there's at least got to be 4 to kind of, assuming it's like a majority vote. And if it's a split, that's going to be a problem. Sometimes what you can do, now when you have uneven, it's easy enough because you're always going to have an odd number out. But if you have 2 people, what I'll do sometimes is I'll say, if we can't agree, you'll name like your accountant a lot of times as being the tiebreaker, or some financial person that you trust. And that's a really easy way of dealing with that tiebreaker situation is, that way you don't get the deadlock, okay? But let's go down a little bit. So the effective dissolution is you can dissolve the company. This is under 1230. You can still wind up the business, okay? So I actually just had this question come up, which is, well, wait a minute, this company's been shut down. What do we do about it? You can shut down the company so that you're not continuing to pay the state, but you can still wind up the business. And know that under the Business Corporation Act, if you've shut down a business, you have 5 years to kind of reinstate it. So you're not going to lose that liability shield. Now, I have had a situation where someone shut down a company and got a liability after the 5 years. They became personally liable. That's the downside of it. So what I tell people is that if you have any potential liability, pay the fee annually to the Secretary of State, because it's not a lot, just to keep that clock kind of going forward. Honestly, it's worth whatever couple $100 you got to pay on it. 1250A, a court can dissolve a company. So a court can come in and do it to pay the creditors of an insolvent corporation. Okay, so if I think about situation you were saying at the bank, right? Bank has that right. They can come in, you stiff the bank, bank's coming in, I'm shutting you down, and we're going to appoint somebody. But even a smaller one, a vendor, a supplier, anybody else small has a right to come in there and say, you know what, they're rendered insolvent. So that's why when the person brags about how you're not going to get paid and they write it in a letter, that can actually be a trigger. That could be an exhibit that simply says, you literally just said you can't pay our bills. And under this section of the Act, we're going to shut you down. Well, you can't do that. You're not in a company. Well, guess what? I'm a creditor. The court can do it for me. And then it says, because a corporation can no longer function. I say various reasons. Why do I say that? It's not the same as the deadlock situation below that. It's not that you can't agree. It means that the company is a somewhat unique situation, so that certain activities inside are rendering it, they can't function as they should. You'll see that as often actually in a non-for-profit corporation where the actual, you have donations and stuff like that where things are getting messed up. That's a big deal. You get screwed up with the IRS. But even in a normal company where you'd have like a very unique piece of technology or kind of the service, or you have time-sensitive types of things that have to happen. You can imagine somebody who's in kind of maybe the financial or regulatory field where because of the inactivity, other bad things are going to happen that can't be fixed. So it's open-ended, but courts would have to interpret it. You don't want to get to that position because you're going to be litigating a lot before you ever get to a determination about whether that's good. The deadlock would be kind of a very typical one, right? A court can dissolve a deadlock business if irreparable harm will occur. Irreparable harm is, if you've ever been in a situation where someone tried to do a cease and desist and they try to shut you down, you have to establish irreparable harm. Courts take action when money doesn't solve anything. That's what irreparable harm's about. So what it's saying is basically there's no remedy inside of the company to save it. So for example, if there was a situation where a loan could be made and it would break, I'm just kind of throwing out some kind of strange examples, but let's say that would be enough to solve it. Or for example, a certain action could be taken to solve this specific issue. That's not deadlock. Deadlock means that the company cannot function. Two people literally, like that early picture I had, where they're looking opposite directions, they're like, we're not going to do anything. That's true deadlock. The court can then dissolve that company. Okay? If the board, now, let's say how long can you go and do no activity? The second is the board's not acted for 2 annual reports. If the annual report hasn't been filed for 2 years or there's really no significant activity, then you can act. 2 years, a company's done anyway, but at least there is that time period. Know that if people aren't doing anything for 2 years, someone can come in and pretty much get the company dissolved. Fraudulent or criminal activity, right, that's pretty obvious. That would be embezzlement or fraudulent, true fraud, and then wasted corporate assets. Wasted corporate assets would be, real estate would always run into that situation where someone's just not taking care of it, like farm, you're not tilling it, or you're just, even a space like this, you're just not running it out, you're just letting it deteriorate, you have a ton of violations. If you go down, now let's look at some remedies. You can appoint a receiver. So receivers are super expensive. A receiver runs your company, and it is a company that runs another company, and you're an asset under management, okay? So that company's done. It's like if you went to bankruptcy. It's literally the same process at that point. They're liquidating assets. You may get paid, but you're probably not going to get paid. You know, the secured creditors are doing it for themselves. The receiver's probably going to be controlled by a bank or some other large secured creditor. The forced sale of the business, it allows for an appraiser. So there'll be a forced appraisal. And then allows for the sale to other shareholders after 90 days. So after the suits happened, in a 90-day window, then the court can approve the sale to other shareholders. So, you know, you have a situation where you have a couple people in the business, a couple want out, but there's one who's like, I'll buy it. I got some investors who want to do it. They don't have to wait forever. After 90 days, that process can get started. And then finally, it says it allows the court to pay professionals involved in the dissolution, including receivers and appraisers. I say that because everyone else is getting paid first. Just like if a company gets bankrupt, every professional, the professional fees in these arrangements always seem to be higher than the average. I don't understand why. It's amazing how people who would charge a couple $100 an hour suddenly are charging $600 an hour. But it happens, right? I mean, it's just because of those systems. And so it's just, the money's just way too much. So this is the one that you want to take. If things go bad, if you have a corporation, look at this. I'll give you this in the next slide. Those are the dissolution of the LLC, 805 I-180/35, and then the partnerships are 805 ILCS 206/103. Notice the 805 ILCS. Okay, notice how they're all the same. That's because that's the whole section of the Illinois statutes that deal with businesses. Okay. But this is a quickie, right? If you go right to those sections, you're going to get your quick answer. But if you're doing this, you're probably doing it through a lawyer because you're trying to do it. But just know that you do have rights if you come down to that, okay? All right. So then I want to just wrap up here with the mediation side. So as I told you, you know, private mediation is an option. You don't have to just go to a judge. You can go to, you know, a professional like myself. There are entities that do it as well. And it's good for small businesses because of the expense that goes with it. And there's no cheap way of going to court. There just is not. You know, I had people call me up, oh, it's just a $5,000 case. We can't handle $5,000 cases because there's no such thing as a cheap case, right? I mean, if you go to court, and this is an exaggeration, your minimum price tag is probably $10,000. So, you know, when you're talking about a business, imagine that a business is a service business and it's just kind of hand to mouth. If I told someone that they were going to pay me a minimum of $10,000, they're like, well, we're shutting our doors down, right? But if I go to a mediator, I can control that. Maybe a half day is all I need. Maybe it's a couple $1,000s. You see, so you can control the cost. So that per diem fees is a big, big deal. The family members and the friends or whoever involved get respected. That's another thing. So again, we deal with family-owned businesses. That's what happens for this. The business is secondary to all of the dysfunction in the family. The mediation process at least can somewhat heal that, or at least make this so that when everybody walks away, they're not happy it dissolved, but at least they're somewhat friendly, or at least they don't completely hate each other. So that's the idea, that you want to keep that respect. And then the bottom part of it are practicalities, which is to say, if you're in mediation, you can set up procedures by which you keep the company running, put somebody in charge to do certain things while you're trying to work it out. Now, ideally, if you had a contract that would say you can allow mediation and it'll have that in place, but even if you don't, this gives you a chance in a friendly environment to craft it again. You can come to the mediator and say, what do you suggest as far as ideas to put this together? And then you kind of have a plan of action. So, you know, just kind of keep that in mind. And how that works is, this is kind of like the snapshot of how that mediation would work. You select a neutral mediator. Both sides can usually make that decision. You provide a brief write-up of what it is. So instead of having to get documents upon documents, you say, here's the issue that we're dealing with. The mediator kind of gets up to speed really quick. Mediator can review those submissions and kind of come up with some ideas. And then there's a couple different ways you can do mediator. So there's those who work with you to kind of come up with your own solution, and then there's those who give opinions. So you can choose that up front. You're like, we don't know what we're supposed to do. You tell us. People actually come into my office to retain me as an attorney, and they say, well, can't you be a neutral? I said, no, I have a conflict of interest. I represent you. But he's going to agree. but I can't. But if they came in together and said, I want you to be a mediator, then that's good. So I tell people up front, before you tell me your case, consider if you want to use me as a mediator, okay? It can be binding or non-binding, which is to say it's binding on, when you can go into court and enforce it as a true contract, or non-binding, we want to try it out, and if it doesn't work, we still want to have all of our rights, including going to court. That's an option. And the other thing that's really important to understand is you don't have to use a one-size-fits-all method. And I use this situation about the rules of negotiation can include non-traditional ideals and methods, including faith-based approaches. I say that because I think that's forgotten, especially when you deal with church disputes, okay? So imagine that you have someone who wants to remove a pastor from a church, or they don't want that dealt with in the same way as you would go fighting between two arm's-length people fighting over a product. You can set up whatever methodology that you want, and the rules, what would be legal rules, can be superseded by these. So sometimes if you ever read agreements, for example, in religious-based organizations, we have to do it by these certain principles, and so those can all be factored in. But if you go to a court, sometimes they're going to apply them, but a lot of times what they're going to do is they're going to say, the Business Corporation Act says that. It's nice that you have these, but we're really bound by these. And you're like, yeah, but you don't understand. And they're like, yeah, we don't have to. And it's not that mercenary, but it sort of can come off that way. I will tell you that your sense of respect when you go into a courthouse is diminished because you're one of many. Most of the times you will be told, do you know how many cases like this that I have? And you feel like you're this small, even though it's really important, whereas you come into a private mediator situation, they're like, thank you guys for coming. Your family matters to me, your business matters, and everybody's respected, okay?
Thank you again for watching this informative session. If you have any questions about what you just heard or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.